Hello, everyone. Welcome to IPWatchdog Unleashed, where each week we journey into the world of intellectual property to discuss the laws, news, policy, and politics of innovation, technology, and creativity. With analysis and commentary from industry thought leaders and newsmakers from around the world, IPWatchdog Unleashed is hosted by world-renowned patent attorney and the founder of IPWatchdog.com, Gene Quinn, who has twice been named one of the most influential people in the intellectual property community and recognized numerous times as one of the top IP strategists in the world. Take it away, Gene.
Thanks, Renee, and welcome everybody to this week's edition of IPWatchdog Unleashed. And this week we're going to be talking with Hilary Preston. And Hilary is a partner with Vinson Elkins, where she serves as co-head of the firm's intellectual property and technology litigation practice and as co-chair of the firm's women's initiative. She focuses her practice on litigation in the intellectual property space, and she's representing clients at both the trial and appellate court levels across the country. Hilary also has substantial experience counseling clients in risk management surrounding technology development, particularly with respect to sports, media, mobile content delivery, e-commerce, and much more. We're going to talk to her about all of these things. Hilary, thanks for being here today.
Glad to be here.
So, Hilary, let's start at the very beginning if we can, or maybe not at the very beginning, but the very beginning of your IP and litigation journey so the audience can kind of get to know you a little bit. How did you get involved in intellectual property in the first place, and how did you get involved in litigation? And whichever one makes the most sense to start with, because I don't know whether you started in IP and got into litigation or started in litigation and got into IP, but I'd love to hear that story.
Happy to. So I am in the category of people that is a litigator first and an IP lawyer as a later development in my practice. But it is for me really kind of a homecoming story. So I studied physics in my undergrad for no reason other than the fact that I thought it was challenging, interesting, shed some light on how the world worked, not to be too dramatic about it, but studied physics in undergrad, realized that that was not going to be the pure academic path for me, was not my future. I didn't want to spend my time in a lab for the rest of my life. So found my way to law school, started out doing general litigation, so everything from antitrust litigation to SEC investigations to commercial disputes. But over time, found I really missed things that allowed me to engage with nuts and bolts technology issues. So 4 or 5 years into my practice, I started coming back to some of my love of technology and love of real science-based disputes. And over time, that became the focus of my practice.
So how long have you been involved in doing intellectual property litigation?
It's been a while now. I think I'm coming up on 23 years. So 23 years at the firm, and I have been doing IP litigation pretty much that whole time.
Do you think it's changed over time in any particular way? I can follow up, but I don't want to follow up. I want an open-ended question on purpose. What, if anything, has changed in IP litigation during your time over the last generation?
Yeah, a lot of things have changed. I mean, some of it is structural. When I was starting out, we had cases where you still had 24 defendants all in the same case. There were some statutory changes that made that not a possibility anymore. So the nature of litigation changed. Instead of having one rights holder, one patent holder suing 12 different alleged infringers all in one case, you started to see and had to see one-on-one litigation. And then, of course, we've had dramatic changes over the years on where those disputes are heard. We have had venue decisions. 23 years is a long time. So we've had Supreme Court decisions on venue, which has meant where, in particular, foreign defendants can be sued has changed, where domestic defendants can be sued. So you have kind of the structure of the litigation and the location of the litigation has changed a lot in the last couple decades.
One of the big pieces of news that we wanted to cover that some people may not even know yet, because by the time this gets published, it will not have even been, I think, a week old. But Judge Albright has announced he's resigning. I mean, that is going to be a big change in and of itself. So let me first ask you, have you ever had the opportunity to appear before Judge Albright?
I have, yes, many times. So Judge Albright has been on the bench in the Western District of Texas for, I think, 6 or 7 years now. I've tried cases in front of him. I've had countless discovery hearings, Markman hearings, other contested hearings in front of Judge Albright. He's also very engaged with the legal community in Austin, where I currently practice. So many of us do know Judge Albright quite well. Yes, I think it's a huge change. I think, as some of your listeners will know, when Judge Albright was appointed to the bench, he made a very focused effort to draw patent litigation to the Western District and wanted to create an environment where those cases could be tried efficiently and with some expertise in patent litigation. And he succeeded in that. So we had a very significant percentage of cases that were filed and tried in Judge Albright's court. There have been some ups and downs in that percentage, but it's been double-digit percentages of national cases have been heard in front of Albright since he's been on the bench. So I think with his announcement that he's going to step down later this year, that will create near-term challenges for a number of cases that are in front of him. I have a case that is supposed to be tried in his court in August. We'll see if that gets reassigned to another judge or if he is on the bench long enough to hear that case. But I think it will also result in a number of changes for where plaintiffs file suits for years to come. Probably we'll see more cases filed in the Eastern District of Texas, which remains a very busy spot for patent litigation. Probably more cases in Delaware and potentially in the Northern District of California.
The older I get, the more I wonder whether I really understand what's going on anymore at all. Because when I've got to know Judge Albright a little bit, not as much as you all know him in Texas, because he was one of the leading patent litigators in the country before he took the bench. So I'm sure you've had much more of a relationship with him than I have. But I just never understood what the problem was with a patent litigator who becomes a federal judge, then having patent cases. And it seemed like there was just this, oh, well, he's doing something, unseemly by encouraging people to file patent cases. Well, he's a patent lawyer. I mean, that's what he does. He enjoyed it. He likes it. And it just also not to say anything bad about Judge Gilstrap. I think he does a great job and is a great jurist. But even when Judge Albright was getting most of his cases, when he was at the high water mark, Judge Gilstrap was still getting a ton of cases. There were still plenty of other judges getting a lot of cases. And it felt a little bit to me like it was Judge Albright was more willing to give patent owners a real fair shake. And not to say that they always would win. I think it probably would frequently win, if maybe not almost always win, on the early pleadings so they could actually get into the case to see what it was about. And I just don't understand in this specialized world that we live in today, what the problem is with having somebody who likes patent cases and understands patent cases being the judge. There's a lot there, and some of which you probably shouldn't respond to, but if you want to respond to anything that I've said without upsetting any of the other judges you appear in front of, I'll give you the opportunity.
I don't think there is, for those of us that practice in this space, I don't think there is anything, quote, wrong with creating a court that is equipped to handle patent cases. What you get as a result of that is a judge who knows what he's doing, a judge who understands how the early stages of a patent case are supposed to proceed. You also get clerks in that judge's chambers who want to handle patent cases and have a lot of expertise there, which is very useful for those of us trying cases in those courtrooms. So I think, at our firm, we have had cases both as plaintiff and defendant, of course, in Judge Albright's court, in Judge Gilstrap's court, and throughout the country. And I think you just have to know your audience. If you are dealing with a case in a courtroom where that judge has never heard a patent case, that's incumbent upon the lawyers then to spend some time with educating them about how patent cases work and make sure that you're doing what you need to give that judge all the information he or she needs to make a decision. That's not true when you're in front of a judge like Judge Albright or Judge Gilstrap or many others, where they see a sufficient volume of those cases that you can sort of shorthand some of your presentations. Oh, it's really both of the systems work. I think people just have to be prepared for which courtroom they're in.
Yeah, I guess both of them do work, and not to belabor the point, but, it just always struck me as odd, particularly when people were complaining about Judge Albright, maybe because I knew him a little bit, so I was like I felt like it was unfair, number 1, and number 2, it strikes me that, like, if you or I, as lawyers, were gonna do, come one, come all, you got a problem, I got a solution, I can do everything from slip and fall to mergers and acquisitions, the patent litigation, the antitrust, the criminal defense, to landlord tenant, to leases and government contracting, and it's like, "Oh my god, my head is already swimming." If we did that, the ethics police would knock on our door and say, "Hey, Gene, what are you doing? You can't
Yeah.
do all this stuff in 2026. You know it. We know it. Stop, or you're violating your duty." And yet we still live, and this is not a problem with any particular court, but we still live in America with this illusion, I think, this dream that judges can handle everything. And I realize judging is very important and specific skill set. But I, for one, to wrap it back into this conversation, would love to see a patent district court.
I was going to say this sounds like an issue we need to present to Congress because, of course, as you know, we have a dedicated court of appeals for patent appeals. The federal circuit, all of our appeals, regardless of which district court throughout the country they come from, they all end up at the federal circuit. So you do have a panel or an en banc panel of judges there that are experts in patent litigation. And then you have judges throughout the country who have a variety of different levels of expertise. So I think the idea of a focused district court practice would be interesting. I think, and maybe I'll keep my fingers crossed that that will be a priority for Congress, but I might be a little skeptical on that one.
Yeah, I think your fingers will go numb if these by the time they get to uncross them, if that's but it's a good idea, I think. I think in the world it just getting more and more complicated and I just feel like it has to do and then they tried to do it to some extent, try in air quotes when they did introduce the pilot project for the patent litigation cases going to certain judges who volunteered. And initially, they were going to get extra clerks and some extra funding to do all this. And then all of a sudden, the extra clerks and extra funding went away. And then, maybe not surprisingly, so did the volunteers to be involved in that pilot project, who were just at that point going to take on additional work. I don't know. This is small potatoes, I guess, given all the other issues Congress is facing. But for us, it's an important one.
It is an important one, but ultimately, I think it comes back to those of us that practice in this space. It is our job to make sure that we present the issues in a way that whoever your judge or jury is understand them, and that's not easy, but that is our job.
All right, let me pivot just a little bit here because when I was looking at your bio, when I see that you're counseling clients dealing with risk management and the areas of sports and digital media and mobile content delivery and e-commerce, and I suspect for those people in the audience who are maybe a bit younger, maybe even in law school or trying to figure out what they want to do with their career, they see sports and their eyes light up and they're like, "Oh my God, I got to be a sports lawyer." I've heard that so many times. I'm sure you have as well. Or, "Oh, digital media. I got to be an entertainment lawyer. I got to get into this space." And when I look at that particular constellation of things that you're doing, what I see as a content creator is it seems like you're talking about the content creation and the protection of originality, whether it's in the form of sports or media or content or the platforms for e-commerce. And to me, that's even more exciting than being quote unquote an entertainment lawyer or quote unquote a sports lawyer. But how do you describe what it is that you do in that particular space? Maybe like at a cocktail party, trying to explain it to somebody. What do you say?
It's a great question. My interest level at a cocktail party is probably pretty low on things like this because I get right into the weeds of what we actually do, which people zone out and walk away, which is fine. But, I think I would frame it as what our group does and what I do and have done for decades in this space is first look at what are the needs of the clients that you're working with. And I mean, what are their business needs, not what is the particular need of this dispute or of this discrete issue that they've come to you with. And in whether it's the sports industry or the media industry more broadly, as everyone knows, the name of the game right now is in streaming and in making sure that you have your content available on platforms that are widely accessible and that work. And so, where our group comes in is in looking at the technology behind those platforms. What video encryption techniques are used? What content delivery networks are used? What are the IP coverage landscapes on the user interface that's involved? So, when a client is looking to make sure that they can get their valuable content out to their customers or fans, there is a lot of back end hardware and software that is involved in that effort. So, our job is to look at what the ultimate goal is of the client, assess what the risk looks like, meaning, are there particularly large patent holders or portfolios that relate to this tech issue? And if so, do we need to talk to them about a license? Do we need to do an infringement analysis to maybe modify something about our system such that we can take that risk off the table? Or do we need to partner with someone who already has infrastructure in place that makes that content delivery more turnkey for whoever the client is? So it's a wide variety of issues that the team works on, everything from assessing that risk at the front end to contracting around it when you're doing project development with someone else, and ultimately to handling any disputes or litigation that arise when either something couldn't be negotiated away or it just sometimes you have litigation that comes up as a bit of a surprise. And that framework, assess the risk, mitigate the risk, contract around the risk, and then litigate it if you have to, that framework applies across industries. But I have spent a lot of time in that industry, in the sports and media industries.
That's what I was just going to say, because one of the things here is and I know a little bit about this space, being, as having spent so much time in content creation and so forth. And I also, at an earlier point in time in my career, I taught sports law, I taught entertainment law at law schools. And then, you're an IP person, so they think that that's gets thrown to you. And it was fun, it was great and all. But the students always think that it's something that it's really not. Oh, how do I become a sports lawyer? How do I become an entertainment lawyer? Well, first you got to be a lawyer, number one. And then oftentimes what I always found is your clients define your practice. So you're not necessarily a sports lawyer in that, like Scott Boras, like signing as an agent, negotiating contracts with teams or something like that. But you're operating under the sports or under the sports umbrella. You operate under the entertainment or media umbrella for reasons that could affect any number of companies, whether they're sports or whether they're media or publishing or studios. They're all online presence. They're all using different tools. They all need tools. And what makes it unique is across that, they're also producing things that are copyrightable, among other things, dealing with rights of likeness. And with new medias, those things are often very interesting. But what advice do you give to people who look at that and say, oh, I want to get involved in this, to bring them back down to reality?
I think it's two things. I agree with your statement that there's no such thing as a quote sports lawyer or a quote entertainment lawyer. Those are industries. Those are not areas of the law, right? So what I do on a day-to-day basis is IP and tech litigation, and that front end of that is the risk management that comes before the litigation, and hopefully helps clients avoid the litigation. So I think the advice is, if you are in a law firm or otherwise in the legal field, first you have to have an area of subject matter expertise that is going to be useful to that industry. So for me, that is understand the technology behind the products that are driving revenue for whatever industry you're talking about. In sports and media, that happens to be things around video creation, video delivery, as one example. Another area where we spend a lot of time and discussion is around all things related to the energy industry, right? So those technologies are different, and increasingly the line between energy and technology really merges as we get into more energy transition throughout the country. The issues that our group brings to bear are the same. They are, what is the technology that's driving this important business issue for you? How can we help you either mitigate the risk or resolve a dispute if you have a dispute in that technology? So the advice is develop a skill set that's useful, And then also know your client's business, because again, it always comes back to the clients that come to us. They come to us for not only our nuts and bolts legal advice and ability to write a good brief, for example, that's a small detail. They come to us because we're good counselors. We help them solve business problems. And you're not able to do that if you don't take the time to understand what's going on in that particular client's industry.
You're speaking music to my ears because I think far too many lawyers get running in this rat race on the treadmill, and you're doing this and doing that. And then next thing you know, you look up and it's just a bunch of transactions, one after another after another. And you didn't stop along the way to figure out, well, am I really helping the client? Is this really what the client needs? Because sometimes clients come to you and they think, I need X, Y, and Z. And then you hear what their problem is, what their real pain point is, and say, you don't need X, Y, and Z. You need A, B, and C. You just didn't even know it. How often does that happen to you in your practice?
Every day, not an exaggeration to say every day. Sometimes the problem that a client comes to us is very discrete. They have been sued, and our challenge is to figure out how to either position them to win that lawsuit or to resolve it on terms that are acceptable to them. That is the exception rather than the rule, right? That is a discrete problem that only has a handful of solutions. Most of the time, a client comes to you and says, we're thinking about developing this new product. What should we do? Now, there's a range of issues that are involved in that. That's where we come into what we really call sort of innovation governance, which we like to think of as a more holistic approach to what are essentially IP issues, but you're looking there at, okay, you have a business need to either develop this product or to find a solution in the marketplace for that product. How can we help you do that? We can look at what areas in this tech industry or in this area of the energy industry have been litigated. Who are the big players in those disputes? What are they fighting about? How can we avoid that problem for you or proactively go out and, get a license to that technology? So thinking a bit more creatively about what the client's actual goals are and helping them find a solution is something we spend a lot of time talking to our lawyers about.
And you referred to that as innovation governance. Did I hear that right?
Yes, innovation governance doesn't mean anything other than think carefully about how you as a business are managing and protecting the innovation that you have, because every company has some IP rights. It might not be at the forefront of their business like it is for sort of high tech industries where they think about it naturally as part of the business model, but every company has IP issues. So, depending on where that IP issue sits in terms of value among the company's assets, they spend more or less time on what we would call innovation governance. So that is who invented the technology, who owns the technology, what are the litigation risks around that, how do we help you avoid litigation or resolve it quickly and efficiently. That package of advice I would refer to as innovation governance.
I love that term. I love that way of thinking because it's much more holistic. And I mean, my mind is racing. I got several questions. I guess the first question that I get a lot of times from folks is other attorneys is, well, how do I get to the point where I have clients that are that sophisticated, where because sometimes when you're starting out, and we've all been there, right? The client walks in, they got a problem, you have to triage and you address the problem. Then I don't want to tell you what I'm working on. You don't need to know. All I need is I need X and Y from you. I don't need Z. And but that's fine. It pays the bills. It's good work. You could do high quality work and have a rewarding career. But I think a lot of us went to law school to do a little bit more than that, to be more strategic, to really help the client and be a value add. So how did you make that pivot? Because I'm assuming you started that same way, like where the clients you get are maybe not as open to your advice at some point. And then all of a sudden we wake up and then everybody's just wants to know, well, what do you think? How do you think? What should we do? What's that transition look like?
This is not a sexy answer, but I think it has the benefit of being true. That is a process that takes time. And it takes time in that you have to build that trust with the client. You have to show them that you are keeping their interests and their goals front of mind. And you do that bit by bit. So, in the example that you gave, in the beginning of a lawyer's career, you might have a discrete problem to work on for a client. Do the best job that you can on that and pay attention to what's going on in the marketplace. If you see another development that is 5 years down the road that relates to that same problem that you solved for a client 5 years ago, reach out to them about it. Let them know, did you see this new piece of legislation? Did you see this new high profile dispute that I think relates to that issue we talked about last month or last year? You start to demonstrate, and it starts to become of your regular practice, that you're thinking about the issues that could matter to them, maybe sometimes even before they do. And it's okay if they say, no, thank you. I don't need your help on that. That you've still laid the groundwork to show them that you are thinking about their business and that you have a knowledge base that will be useful to them.
It's interesting that you say that, because one of the things that I've written about increasingly over the last several years is rainmaking and relationship building and networking. And one of the things that I always try and tell people is that if they don't know who you are, they're never going to hire you. And then number two is once they know who you are, unless you're literally the best at what you do, you have to be likable. Now, if you're literally the best at what you do, you're going to have enough clients that you could be a real jerk. Not to say you're a jerk, but you can be, right? But that's not a strategy, right? So, and then I've talked to a lot of in-house counsel over time, and they all tell me versions or varieties of the same thing, which is, tell me something I didn't know about my business. Because if you tell me something I didn't know, whether it's, hey, did you realize your major competitors are doing this and I notice you're not doing that? Well, that's useful. And oftentimes these in-house people, they're starved for resources. Their departments are smaller than they should be. And they don't know everything you think that they would know about their own business or landscape. So it's music again to my ears to hear you say that, because reaching out to people like that really does develop an expertise and a trust. And it also has the benefit of, I think, oftentimes getting work.
Absolutely. I mean, we are trying to run successful law firms, and that can only happen if we have a sufficient number of clients who want our services. That's sort of the basic premise. But I think it is not just thinking about those relationships cynically as transactional, right? It is genuinely thinking about, how can I be useful to this group of people? That is the way you build those relationships. And I think when you're earlier on in your career, the advice that I give to people is put on your framework of, how can I make this in-house lawyer's or this in-house business person's day easier, right? You might not be thinking about what are the most important business or legal issues they're going to face next year. You might not have enough knowledge and background and perspective to give that kind of advice yet, but you can think about, how am I going to make this person's day easier today, right? If I give them a draft that is a new draft from what I sent them a week ago, take a minute and write a cover note to explain what has changed, attach a red line. These are very simple things, but if you think about it from the perspective of person on the receiving end of that, as you said, is overworked, under-resourced, has every manner of problem on their desk, make yours easy for them. Make your part in their day easier for them.
I love that. So let me ask you, we're talking about business here, and I didn't mean to suggest that about the transactional nature, because I try and get away from that, because I just don't think that's the way that you can maximize your value. It's maybe the way you initially get clients. It has to be, I suppose, on some level. But if you're really doing good work, you're really helping the client do what it is that they need to succeed. And if they understand that and value that, then you're going to just succeed as well. And I have gotten to a point in my career, and I suspect you probably have too, I don't have to work for people I don't like. So if I'm working for you, I like you on some level, and I enjoy helping you. I mean, that's a big part of what it is that we're doing. But the one thing that I find really interesting is we all went to law school to be lawyers. Then you get really good at being a lawyer, and then all of a sudden, you then are now a business owner. And very few lawyers have ever had training on how to be a business owner. And I was wondering, how did you come to that? Did you come to it naturally? Did you study it? Did you read? Are there any books you would recommend?
In terms of the business side of law?
Yeah. How did you go from being like a litigator that people want to hire to now you have a business portfolio with respect to the firm that now you have to contribute to running the firm? And it's not just being a legal practitioner, because you we spend all of our career trying to get really, really good at doing the law, and then all of a sudden the promotion is, okay, well, now you get to run the business. It's like, whoa, where did that come from?
I think it takes time. I think that at our firm, we have the benefit of a lot of people more senior to us that can sort of show you the ropes along the way, and also have the benefit of a really excellent group of business professionals. So, people that are not practicing lawyers who help us run the business. But I think it's also just a mindset as you part and parcel of becoming more senior and figuring out how to help clients with their business problems. You naturally put that same lens onto your own operation, right? Where can I be most useful to this organization? I've served in various leadership positions at the firm over my time here, and we view those as service positions, right? We're in service to our partners. Our job is to help our partners and the rest of the firm succeed. And it's a little bit just of that mindset shift.
It is always interesting to hear because I think law schools would do better to realize that the really super successful students are going to become partners in running law firms and or go in-house and have all kinds of responsibilities with the chief IP counsel or general counsel or CFO or CEO. And that's a piece of the education I think that is missing.
I think that's an interesting observation. I think law schools treat it very differently, and there might be sort of an inverse relationship between the quote prestige of the law school and their offerings on some of these more practical things. I do think you see schools that maybe are not in that the T14, the top 14 law schools that have more practical courses. So that might
Mhm.
be something that some of the higher ranked schools can give some more focus on, because it is otherwise you have to learn it while you're practicing.
So let me pivot again a little bit, although I want to go back to what it is that you do with respect to sports and digital media and publications and content and that sort of thing. What I don't see on that list, or at least maybe it is on your bio somewhere, but I don't see AI or machine learning on that. I suspect, though, you are involved in that on at least some level. Is that fair to say?
Yes, absolutely. I think you'd have to be living under a rock to not have some part of your practice intersect with AI and machine learning.
Yeah, so this is the obligatory part of the conversation where we talk about AI. It seems like it's you have to have that conversation no matter what it is you're talking about because it just is encompassing everything anymore. How is it, maybe two questions. How is it affecting you and your practice, and how is it affecting your clients?
I think this will be perhaps one of the left turn answers to that question. So, I think one of the things for our firm and for our practice throughout the firm that is development in response to the country's focus on AI, and I don't think it's an exaggeration to say that the whole country is focused on AI, is where is all of that compute going to run, right? So for us, we have a deep history in energy and infrastructure. So we're working with clients on a daily basis. Where are you going to build the data centers that all of these companies need in order to run the compute so that we can all have fun using Claude and ChatGPT and whatever other tools we want to? There is a very real hard assets question to where does that happen? And so, what we find ourselves doing is spending a lot of time working on either the project development that goes into data centers or the energy generation issues that happen in order to power those data centers. Those are being built in places and at scale that can't necessarily just plug into the grid. So it's not directly a AI issue, but it is an AI impetus for situations that we're spending a lot of time on in our corporate practices, work on the project development. But even from an IP side, we're seeing a lot of really interesting issues about who is going to own what IP in those projects. And we're starting to see litigation come out where certain patent holders are starting to assert their IP against some of these higher profile projects. And I think we're going to see more of that.
Yeah, that's probably a prediction that you could say safely and know you're going to be right. I mean, this is going to be the Full Employment Act for all litigators, for probably all lawyers, really. AI is going to be the gift that keeps on giving for a very, very long time. maybe ever more, really. I mean, because it's going to be ingrained in everything that we do. It's interesting that you focused on like where things are, because that's something I think about a lot because I live in Northern Virginia in the Northern Virginia corridor, right around Dulles, going down towards DC. And in that corridor, if those people are listening to this all around the world, around the country, and you're not familiar with that corridor, that is AI data center central. Now, I don't understand. I don't get it. I mean, it's probably good for all of us because the property values are going up. It's not so good because the energy costs are going up. But bringing all that into this space, I get that's, the historic home of AOL where it all started in Reston, right in that area. So the on-ramp makes a lot of sense why that would be high on the list, but not a cheap area to be doing this stuff. I mean, I remember the commercial from many years ago at the dawn of the internet where this business guy gets hauled off into the middle of nowhere, like Nebraska or Wyoming or whatever. And his guy is saying, we should build our warehouses here. And he looks at it and he says, why? He says, there's nothing here. And he said, because it's $4 a square foot and the internet, and then his eyes open up and like, oh my God, it just seems like there would be better places to put it. I would probably put it in a colder area because the heat is just ridiculous. So let Mother Nature help you a little bit. Maybe close to a body of water so you could get some cooling and geothermal. And is that the type of stuff that you're doing, that kind of work and permitting and risking out all this stuff?
Yeah, our firm spends a lot of time on those project development issues. And it's, we probably would need a couple of hours to sort of go through all the considerations, but it's everything from the logistics of where can this be built? Where is there space? I think one of the things that we're seeing really as a driver in that consideration is where is it near an energy source? Because
Mhm.
those data centers are monstrous consumers of energy, and of course, as you pointed out, they require large cooling systems as well. So there's a lot of different considerations that go into that. And then there's, of course, a regulatory overlay for where can all those things happen and how quickly can they be built. And that is going to be the project for the next, I won't predict 10 years, 20 years, I'm not sure, quite a long time.
I don't know, but if you guys are doing that and you're willing to have a conversation, I will have you back because that really excites me. I know I'm a nerd. Like I'm an electrical engineer. Power systems was what I focused on power systems and computer architecture were the two things. And why? That's kind of weird. Two different things. Totally. Yes, they are, but they were among the easier electrical engineering courses. So I had to focus on the periphery. Otherwise I was never going to get the degree to begin with. But and now power is just so important. Just the short answer here, and maybe we could hopefully do another whole episode on this, but is there like a guns and butter kind of curve between where you put these things? Because it seems to be that, yes, in the desert would be great because the solar power and energy, but then if it's in the desert, it's already 100 and 120 degrees to start with and the cooling. So is there like a formula or are there algorithms or you do this all one-off, like project by project to figure it out?
So I think it's project by project, but yeah, I would welcome that data center specific episode. There's a lot of pieces of the puzzle we could talk about, including all the IP issues that are going to follow there, right? It's an interest because it's got everything. It's got energy generation, it's got cooling systems, it's got all of the sometimes energy storage, depending on what kind of system it is. So you've got the battery technology. It's got the whole lineup of issues that are interesting. And I'm a nerd too, so I share that.
Yeah,
I like those issues.
you're talking my language there because I think fundamentally the next big paradigm shifting series of innovations has to be in battery technology. If we're going to get to where we want to go, because it's cheaper to acquire power on off peak times, and then you need it for peak times. But if you can't store it and store it efficiently, and then also data energy transmission is something that we
Mhm.
need desperately in the U.S., probably all around the world to focus on. So there's a whole lot of these issues, and they are exciting if you're a technologist. Would it be fair to say you consider yourself a technologist? I see you light up when you talk about these tech issues.
It's funny that you made that observation because I give advice to young people all the time that you have got to have some core part of whatever your job is. If you're a lawyer or in any other area, that lights you up. I use that same word. It's got to be something that lights you up, that has to interest you enough for you to be reading about it in all of your spare hours. So yes, I think that's a fair statement.
One of those old sayings about do something you love and you never have to go to work a day in your life. And some of us are lucky. I really like what I do. It's not to say it's not stressful at times and so forth, but enjoying what you do, I think, is so important.
Yeah, absolutely. Absolutely. It's not to say there's not going to be parts of it that you don't enjoy as much, but some core part of it has got to excite you.
Right. Absolutely. So before we run out of time here, and this has been fascinating, great conversation. I really appreciate it. Let me just ask you another open-ended question about where do you see, whether it be intellectual property or intellectual property litigation or technology in general, where do you see it heading? And it's purposely open-ended because I want to just hear what your thoughts are for the future based on what you're seeing in your day-to-day right now.
One of the things that we spend a lot of time talking about and thinking about within specifically patent litigation is in some of our larger competitor versus competitor cases, what role do those cases play in terms of advancing technology more broadly, right? So there is an argument that if two competitors are busy suing each other over the technology that that one of them owns or both of them say that they own, how do you think about that in terms of its overall effect on progress? And that sounds like a big question, and it is, but I think it's something that's appropriate for us to think about. And specifically, it comes up in terms of some proposed legislation that hasn't progressed too far yet, but might, relating to the availability of injunctions in those cases. So, in a lot of cases, in patent cases, you get those cases either all the way through a jury trial, and the result of that is a damages award, right? Or an imposition of a royalty on future sales. Some of those involve injunctions against the other side continuing to do whatever it was that they were doing that was infringing. And I think that issue of what role do injunctions play and should they be more or less readily available is one that deserves more attention than it's getting, because I think we need all the technology solutions that are out there. Should there be some legislation that addresses the role of injunctions, or should we just leave that to the courts to address on a case by case basis? I think is a really interesting issue.
That is a big issue and could take a whole hour talking about just that. I mean, I'm more of a fan going towards injunctions, but not necessarily to tell somebody to actually stop what you're doing. I think of it more as like leverage to get everybody to come to the table. And I think when eBay happened, it took a very important lever away from patent owners and the representatives. But having said that, I'm not unsympathetic to the point that where like you have like a group of lawyers like an NTP buy a patent and then they're going to shut down BlackBerry, and that again, maybe it's just the older I get, I look at this and I think to myself, come on, guys, we can figure this out.
And some people can.
And some people can and some people can't. They throw their hands up and say, oh, we need to go back to what we were saying before, one size fits all, like for district court litigation. It's like, no, sometimes the specialized approach makes a lot more sense. And I think one size fits all, no, sometimes it makes sense to just try and facilitate a resolution. And once you define these things in more black and white kind of ways, the party who's going to win becomes clear that they're going to win, or their path to winning becomes clear. And then that just prevents a deal from getting done. And I would prefer to see far more deals than litigation.
I think most clients would probably agree with that. Yes, and I think it's our job to make sure that we're keeping that top of mind, back to our original point. What is the business goal and how can we help them achieve it?
Yeah. And not to say anything bad about patent litigators or IP litigators in general, because I think in that ecosystem, you guys play an enormously important role, right? I mean, you sometimes you're not going to come to resolution under any cause. And those are the cases that need litigation. And oftentimes you have to litigate in order to create leverage or to make it real. Nothing ever gets done until it's real. And I just would like to see more resolutions at the end of the day. We can work this up and litigate and have all this animosity or whatever all the way through. But at the end, I would rather it come to a conclusion in a boardroom than at the federal circuit.
Well, you're putting me out of a job there, but
No, no, no. You are important to that whole ecosystem, right? And I think in particularly when you start talking about how do you advise clients of the risks that they're facing, because that to me seems like an endless pit of work, right? Because not enough clients, I think, actually think about that.
yeah, and they're time constrained just like everybody else, right? It's oftentimes hard, particularly in fast moving project developments, to stop and think about what are the issues that are going to surface in 5 years, particularly on new technologies. That is a challenge for people running businesses that are trying to get either new products or new projects off the ground. It is not always feasible for them to stop and think about what's going to happen in the future. But when they do have that chance, I think it's tremendously helpful because the most frustrating scenarios that I see clients deal with are ones where they have invested significantly in something only to have it derailed 5, 10, 15 years later by a patent or a series of patents that they didn't know about.
Yeah, well, and I don't think you have to worry about any potential loss of a job because AI, there's so much at stake. And what I've come to learn is that the more that's at stake, the less likely a deal is because people are trying to own the whole universe. Everybody wants to be a monopoly. Nobody likes monopolies, but everybody wants to be one. And everybody fights and fights and fights. And then it becomes your more mature marketplaces that realize, hey, we can actually make more money if we play nice together. And that's going to take a long time to get there with AI, I think.
I'm certain you're right about that. But it is nothing if not dynamic at the moment. Just watching everybody advance on the leaderboard of who has the best, most competitive products. And I think, of course, we'll see more surprises that none of us anticipated. That's been the story of the last couple of years.
That's what makes it fun.
Absolutely.
So, well, thank you, Hilary, for a wonderful conversation. I appreciate you being here.
Yeah. Thanks so much. It was really good talking with you.
Thank you for listening to IP Watchdog Unleashed. We will be back next week, and we hope you will join us again. In the meantime, please be sure to visit IPWatchdog.com to read all the latest news and information about what is happening in the intellectual property world. And also be sure to subscribe to our free daily email newsletter.